During calls with my clients, many tell me that the speed that the officer wrote on their stunt driving summons or the radar, it cannot be correct. They're convinced that their internal GPS or their Waze or their speedometer did not show anywhere near the officer's speed that was displayed on the radar. They want to fight the charge and they want to dispute the officer's data. So let's investigate this. The officer's radar, laser, or any speed capture device, the law, fair or not, has set a baseline that the officer's radar is an accurate measurement of speed for drivers in Ontario. It is calibrated, tested, and it's been used for decades. The technology has been deemed to be an accurate device for determining the speed of a driver in Ontario Provincial Offences Court. Moreover, an officer that is trained and active on the police force is also deemed to be an authority figure in charging individuals with stunt driving. So the court will recognize the radar and the officer as a trustworthy source of evidence against you in a stunt driving case. So regardless of how you feel about this, it is more of a fact than a debatable issue. The court generally sees the officer as defending the law and you as someone that has violated the law, which is why you were charged. So Waze, Google Maps, Apple Maps, or other apps. Well, most navigation apps have a speedometer feature that not only tells you the speed limit, but that you're in, but also tells you the speed that you're traveling. And many times a client will tell me that the navigation app showed a speed much less than the police officer's radar or the speed that the officer wrote on the ticket or summons. They want to know if they can fight the charge using this information. They have a screen cap and they believe that they have evidence. However, the court does not recognize your navigation or any other navigation system as a form of evidence. It will generally not counter the radar device used by the officer. In fact, most times, people charged with stunt driving were not captured by the radar at the time or the exact location that they think they were in. When the officer submits the evidence, it will outline the radar device, the calibration, and the location where you were caught at the stunt driving speed that you were charged with. So just remember, your navigation device, GPS, or internal car devices are for your own use. They are not recognizable forms of evidence. So question is, how can I fight the stunt driving charge then? Well, generally, it's very hard to fight the radar. It's a very objective and determinate in your case. It can be used by the courts as enough evidence to convict you of stunt driving and impose that 1 to 3 year license suspension, that $2,000 to $10,000 in fines and more. So there are other ways to fight this charge. Get legal help from a law firm that specializes in stunt charges so you can keep driving and don't do anything to hurt your case by using apps and devices that are not recognized as evidence.